Welcome to our Arizona Revised Statutes video library. I'm Shawnna Riggers, Managing Attorney at Arizona Family Law Attorneys. My goal is to take this somewhat dry information, make it a little bit more entertaining, and also provide you with information regarding the laws that are applicable to dissolution, parenting time, custody, child support cases here in Arizona. This is being filmed in 2023, so it's important that if you're seeing that afterwards, that you double check the statute to make sure that it is the most current version. And if you have any questions regarding any of the material, as always, please feel free to reach out to us here at Arizona Family Law Attorneys, where we provide peace of mind as there is no substitute. 25.312, Dissolution of Marriage, Findings Necessary. A. The court shall enter a decree of dissolution of marriage if it finds each of the following. 1. That one of the parties at the time the action was commenced was domiciled in this state or was stationed in this state while a member of the armed services, and that in either case the domicile or military presence has been maintained for 90 days prior to the petition for dissolution of marriage. 2. The conciliation provisions of Section 25.381-09 and the provisions of Article 5 of this chapter either do not apply or have been met. 3. The marriage is irretrievably broken. 4. If the marriage is a covenant marriage, any of the grounds prescribed in Section 25.903. B. If both of the parties by petition or otherwise state under oath or affirmation that the marriage is irretrievably broken, or if one of the parties so states and the other does not deny it, the court shall make a finding as to whether the marriage is irretrievably broken. If one of the parties denies under oath or affirmation that the marriage is irretrievably broken, the court shall hold a hearing to consider all relevant factors as to the prospect of reconciliation and shall do either of the following. 1. Make a finding as to whether the marriage is irretrievably broken. 2. Continue the matter for not more than 60 days for a further hearing. At the request of either party or on its own motion, the court may order a conciliation conference. At the next hearing, the court shall make a finding as to whether the marriage is irretrievably broken. D. A finding that a marriage is irretrievably broken is a determination that there is no prospect of reconciliation. E. To the extent it has jurisdiction to do so, the court shall make provisions for legal decision-making and parenting time and support of any natural or adopted child common to the parties of the marriage entitled to support, the maintenance of either spouse, and the disposition of property. So this is a really long statute. It includes a lot of really important factors. Most importantly, it confirms that the spouse, one spouse or both spouses, must have lived here for 90 days prior to the filing of the action. It also confirms that the court needs to find that the marriage was irretrievably broken and discusses the issue of conciliation court. The court here in Maricopa County has conciliation services, and the other counties also have conciliation services. I'm just most familiar with Maricopa County, honestly. And there is a person that's employed by the court where both of the parties will go. And now it's actually virtual usually. And they'll talk about whether or not the marriage is irretrievably broken. And if they want to have the option to move forward with counseling, they're offered that option. And if one of the spouses denies, then it's not forced upon that spouse, and the court will then have to make a finding on whether or not the marriage is in fact irretrievably broken.